My name is Vartan Manukian and I'm a practicing paralegal in Toronto, Ontario, Canada. If you're new to my channel, I thank you for joining. And don't forget to click the subscribe button and turn on the notification icon. Today, as part of our series of short videos on different types of witnesses, I will be speaking to you about the witness with mental impairment. Public awareness of mental health has increased in recent years. The term mental illness involves a variety of disorders that can be associated with impairment of functioning. In any given year, 1 in 5 Canadians will experience mental illness or addiction problem. By the time Canadians reach the age of 40, 1 in 2 will have or have had mental illness. This means that sooner or later you may encounter a client in your practice with a history of mental illness or treatment. What are the practical ramifications of having such a client? Well, some of the ramifications include whether the client is competent to testify, understands the nature of retainer, and is able to provide informed instructions. Now imagine this. You're gathering background facts with your client. You're assessing your client for the ability to recall facts which gave rise to the offense or the lawsuit. You're evaluating the client's perception, memory, and ability to communicate events. This is important because later, when you're reviewing disclosure with your client, you want to know if your client has the information relevant to make a decision and whether your client is able to reasonably foresee the consequences of making a decision or the lack of it. Generally, it is presumed that a witness has capacity to testify unless incapacity is demonstrated. The issue with a client with a history of mental illness or being treated by a psychiatrist is that of competency. Mental illness does not necessarily mean that a witness is not competent to testify. Similarly, hospitalization does not mean that the evidence of this witness is rendered inadmissible. If a person is being treated, you will want to obtain consent to obtain a medical report and speak to the psychiatrist to see if the witness is competent to testify. Failure to investigate means that the witness may not testify at trial, or worse, a mistrial declared during the trial if the issue of competency comes up. As I've mentioned in previous videos, the hallmark of a good advocate is meticulous preparation. And remember, when discussing competency, we're not just interested in competency at trial, but at the time of the commission of offense. If a competency hearing is required, it is done before a judge and before the witness testifies at trial in a proceeding called voir dire. At this hearing, expert witness or layperson may testify. At the end, the court makes a determination whether the witness has capacity to testify or not. It is important to note that if you obtain a medical report from a physician stipulating that it not be shown to your client, you must immediately return it to the physician without making a copy unless you have instructions from your client to accept it on that basis. If the medical report contains opinions or findings that, if disclosed, may cause harm or injury to your client, you must discourage your client from seeing it, unless the client insists, in which case you have to produce it. You may also recommend that your client attends at the physician's office in order to benefit from the experience of the physician in understanding the significance of the medical conclusions. As far as reasonably possible, you must maintain a normal professional relationship with a client with mental illness or treatment. You cannot abandon your client, but will have a lawfully authorized representative appointed, a topic of discussion which is outside the scope of this video. Many courthouses across Ontario have mental health courts. These courts are designed to assist people with mental and other related issues. Proceedings in mental health courts are less formal than other criminal courts and deal with issues such as assessment orders, mental health diversion, guilty pleas, judicial pretrials, and, in some cases, trials. So remember, Mental impairment does not necessarily mean that a witness is not competent to testify, and whether a witness has capacity to testify or not is left to a judge to decide. If you like this video, click on the like button and check out the next video in the series, The Expert Witness.